So what's the magic ingredient that turns a casual promise into a legally binding contract? Well, it all comes down to a crucial legal concept called consideration. You can think of it as the price of a promise, the glue that makes a deal stick. Without it, a promise is really just talk. So let's figure out what this thing actually is.
And to kick things off, let's start with a real and kind of weird legal puzzle. Imagine this. A son complains all the time. His father, totally fed up, promises to wipe out a debt the son owes him if he'll just stop complaining. The son agrees. Now that sounds like a deal, right? But would a court actually enforce it? Is promising to not be annoying a valid price? This question, believe it or not, gets right to the very heart of what we're talking about today.
At its core, the definition is actually pretty simple. Consideration is the price paid for a promise. It's what each side brings to the table. It's the benefit one person gets or the thing the other person gives up. It's that classic quid pro quo, something for something, that turns a simple promise into a real bargain.
Okay, so here's our game plan for this explainer. We're going to start with that core concept, the price of a promise. Then we'll dive into the specific rules of what actually counts. After that, we'll tackle the really tricky stuff. What happens when a duty already exists? And finally, we'll look at some fascinating exceptions where a promise might be binding even without a price tag.
So let's jump right into Section 1, the price of a promise. Before we get to all the weird and wonderful edge cases, we really need to get this foundational idea down cold.
Now, to help us keep all these rules straight, the source material gives us this really handy mnemonic, ADDR. It stands for the 5 key requirements for valid consideration. We're not going to break it all down right this second, but we'll be coming back to this as we go, so keep an eye out for it.
All right, let's get into the nitty-gritty. What are the actual rules that decide if the price for a promise is something the law will recognize? This is where it starts to get really interesting.
And here's rule number 1, maybe the most important one of all. The price has to be given at the desire of the promisor. This is the A in our ADD mnemonic. You can't just do something nice for someone out of the blue and then turn around and demand they pay you for it. The other person has to have asked for it. It has to be a bargain.
Let's look at a classic case that nails this point down. So picture this. A builder puts up a new marketplace, but he does it because a government official, the collector, told him to. A shopkeeper moves in, and he's so happy about the new building that he promises to pay the builder a commission. But later on, he changes his mind. Was that promise to pay legally binding?
So, did he have to pay? Nope, the promise was totally unenforceable. And why? Because the builder didn't build the shops at the desire of the shopkeeper. He did it because the collector ordered him to. There was no bargain, no connection between what the builder did and what the shopkeeper promised. No desire, no consideration. Simple as that.
Okay, on to our second rule, and this one highlights a really fascinating split between Indian law and English law. In India, the price for a promise doesn't actually have to be paid by the person who gets the benefit. A totally different person, a third party, can step in and provide it. This is a big deal called privity of consideration.
Let's see how this plays out in another classic case. A mother gifts a big estate to her daughter, but there's a catch. The daughter has to promise to pay an annual allowance to our uncles. The daughter agrees, but after a while, she just stops paying. So the uncles sue her. And the daughter's defense is pretty clever. Hey, you guys didn't give me anything for my promise. We don't have a contract.
And this is where the verdict shows that huge split. Under Indian law, the uncles won. The court said it didn't matter that the consideration didn't come from them directly. The gift from their sister, the mother, was enough. But in England, the result would probably be the exact opposite. The uncles would be seen as strangers to the deal and wouldn't be able to enforce that promise at all.
Okay, let's circle back to that question we started with, the father and the complaining son. This brings us right to our third major rule, which is the R in our adder mnemonic. The consideration, the price, has to be something of real value in the eyes of the law. It can't be something vague or silly or just completely made up.
So what happened with our complaining son? Well, the court sided with the father's estate. It decided that a promise to stop complaining just isn't valid consideration. Why? Because it has no real economic value. It's way too vague and subjective for the law to deal with. It's what's called an illusory promise. So sorry, kid, you still got to pay back that debt.
All right, we've nailed the basics. Now we are diving into the deep end, into what's probably the most confusing part of this whole topic, the existing duty problem. This is where the rules start to get really twisted.
So here's the big puzzle for this section.
If you already have a legal duty to do something, like, say, a firefighter has a duty to put out fires, can you demand someone pay you extra to do that job? If sailors already under contract to get a ship home, is promising to just keep doing their job good enough for extra pay? Let's untangle this mess.
This table breaks it down perfectly. The general rule is, no, you can't get paid for a duty you already have. So in Collins v. Godefroy, someone with a public duty to testify couldn't demand payment. But, and here's the first twist, in Ward v. Byam, if you do more than your duty, that extra bit is good consideration. Same goes for contracts. In Stilk v. Myrick, sailors couldn't demand more pay for the same work. This is to stop people from trying to extort more money halfway through a job. But here's the cleverest exception. Shadwell v. Shadwell shows that a duty you owe to one person can be valid consideration for a promise from a completely different person. It's a tricky but really important difference.
Okay, it's time for our grand finale. And for this section, we're going to flip the script. We've spent all this time saying that every contract needs a price, a consideration. But are there exceptions? Are there times when a bare promise, with absolutely nothing given in return, is still enforceable by law?
Well, the law starts with a very clear, very absolute rule. Section 25 of the Indian Contract Act lays it down in no uncertain terms. An agreement made without consideration is void. That means it's worthless. Period. End of story.
Or is it? Because, the law just loves a good plot twist.
That's right. Section 25 itself gives us three big escape hatches. First, if a promise is in writing, registered, and made between close relatives out of natural love and affection, it's valid. Second, a promise to pay someone back for a service they already did for you voluntarily, that's binding. And third, a written promise to pay a debt that's technically too old to sue for, a time-barred debt, that's also enforceable.
And this brings us to a super practical example: charitable donations. When is your pledge to a charity actually legally binding? Well, in the case of Abdul Aziz, a simple promise to donate with nothing else happening was found to be unenforceable. It was just a promise. But in Kedar Nath, the charity went out and hired a contractor based on those promised donations. That action, that reliance, made the promise binding. The law basically says it would be totally unfair to let the charity take a hit after they acted based on what you said you'd do.
So let's boil this all down. What are the key things to remember? 1. Consideration is the price of a promise. 2. Remember that adder mnemonic. It has to be at the desire of the promisor, but can be done by anyone and must be real. 3. Indian law is way more flexible than English law on who can provide that price. 4. An existing duty is only good consideration if you do something extra or if the duty is owed to a third party. And finally, an agreement without consideration is void unless it fits into one of those special Section 25 exceptions.
And that leaves us with one last thing to think about. We saw how a charity relying on a pledge can make it binding. That principle is called promissory estoppel. So where else might this apply in our lives? Think about it. If your boss promises you a promotion and you turn down another job offer because of it, could that promise suddenly become legally binding? It's a fascinating question that shows just how much this stuff matters in the real world. Thanks for tuning in.